You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Welcome to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
And David, I am, again, I always say I'm excited, but as we're filming this episode of God, Law, and Liberty, yesterday, you gave some incredible testimony to the Tennessee House regarding our abortion bill, and so that we're going to be talking a lot about that today, and we'll get to that in just a moment. But one thing I wanted to say, it's something the Lord brought to my heart this morning. Interestingly, through these discussions that we've been having, on abortion. But I want to read. Let me pull it up here. Ephesians chapter 6, verse 12, and God brought this around to my heart, not through abortion, but actually through. I don't know if you might be aware. You're probably not. You've got other things to do, but if you pay attention to the news, we've got this this white cop in Minneapolis that killed this black man. Yeah. It's horrible, absolutely horrible tragedy. George Floyd, and of course, so we're back into the race debate in this country, and it's posed some conversations and some frustrations, and everybody's up in arms, as we tend to get over what we see on the news and whatnot. And of course, it's not something we'll probably ever get in too much on this show, maybe ever, but I'm pretty passionate about the fact that we have this critical race theory and intersectionality that has made its way into the church, which is completely anti-gospel. It's caused some sort of a split in the Southern Baptist Convention. We have the Conservative Baptist Network, and there's a whole host of discussion there. But it brought me to this as I thought about social justice and all these things that we've brought into the church. It seems to me that when we do that, we forget this one thing. Ephesians chapter 6, verse 12 says, "For our battle is not against flesh and blood, but against the rulers, against the authorities, against the world powers of this darkness, against the spiritual forces of evil in the heavens." It's not with flesh and with blood. It's we have an enemy, and that enemy is cunning. He's smart. He's been doing this for a long time. And I just thought, as I thought through that on the race issue, it made me start thinking about abortion and how long you've been fighting this fight. And I just wanted to say, I just felt such a confidence in my spirit that we are going to win this battle on abortion because we know who our enemy is. Our enemy is not Planned Parenthood. Our enemy is not women. Our enemy is not abortion doctors. Our enemy is not the left. Our enemy is not the Supreme Court. We have an enemy, and we know who the enemy is. That's right. And God is working out His purposes against that enemy. So anyway, I just wanted to say that this is God, Law, and Liberty after all, and I just really felt that strong in my spirit that it's really important that as we go through all the things we deal with culturally, we need to know who our enemy is, and if we don't know who our enemy is, we don't win. Yeah, that's right.
And just as importantly, and you're saying this by implication, we have to know who our enemy is, and we have to know who our strength is. And the chariot, the psalmist said, and the horse are made ready for battle, but victory doesn't belong to the strength of the chariots and the horses, it says, but victory belongs to the Lord. And I will just make a confession. We need to get to the political, legal issues that people would care about that took place on, Wednesday. But one of the things that I have not learned in my 62 years very well, and I'm only learning, is to trust in the providence of God, who knows exactly where things are going. It's not that there will be an end and God is sitting here saying, well, I wonder how I'll work this out. Let's see what Gary does this week, and let's see what the governor does this week, and then I'll figure out, what I should do. He's the Alpha and the Omega. He is above time. Things exist because he already knows them to be.
That's good.
That's why in Psalm 39 he says, I saw your unformed parts. I know your days before one was written down. Why? Because God knows in a way different than we know. And what I've been guilty of, even yesterday, is that I can get, I read this morning in 2 Timothy, it says, the servant of the Lord must not strive, must be gentle and apt to teach. And I thought, why can't I be that way? Why should I be that way? It's because I know that all things rest in God's hand. So I don't have to strive. I don't have to get mad. I don't have to get angry. I need to say what I say. I need to say it with conviction. But God's got this thing. And I, my job is to just be a faithful witness in the process.
Amen.
And let him move the hearts of kings. So that's what we were doing, I hope,
that's
on Wednesday.
That's what I saw. And I'm excited for people to get a sense of that and also see this clip. So I sort of want to set this up, and then we'll watch this clip, and then we'll move forward. But so yesterday on Wednesday, you got to address the Tennessee House Public Health Subcommittee on the abortion bills. We have the Governor's Heartbeat Bill, and we have our Rule of Law Life Act, which both, at the end of the day, we want to see Roe v. Wade gone, right? But obviously,
right.
There's a way we feel that is the best way to do that, and that's really the crux of the argument. And so anyway, as you were giving your testimony, Representative Matthew Hill, who is a champion for this cause and a friend and a great, I feel like God really used his question to allow you to elaborate on this point. I really did.
Yeah.
I just felt the Lord on it.
Yeah.
And but he asked you. I think he correctly asserted that, look, as legislators, people elected me to deal with this issue. They didn't elect me just to sit around and talk about it. They elected me to do something, and we need to pass a law, and we need to fix this. So he obviously feels a burden to get something done.
Right.
And so he sort of posed that question to you.
And he did. And part of what's behind his question is, we're the legislative body. We make policy, not the Supreme Court.
Right.
Why are we always worried about the Supreme Court? So both those things are sort of in play here. We have to deal with the court, but the people elected us to do their business, to make the policy. And that's this clip.
So I have your response here to that question. It's about 3 minutes, and so let's take a look.
And I would agree with you that it's your job. And I kind of don't want to say this either. But to me, with what you just said, it's my job to decide, is an unborn natural person, recognized as such at the common law, even in the mother's womb, as we cite, entitled to the right to life that the Ninth Amendment refers to? Absolutely. From the moment we know that life exists and we recognize it in every area of the law. So I'm going to lay down my marker and say, that's a life in Tennessee. It deserves my protection. And I'm not going to run to the federal courthouse and say, what will you let me do? I'm going to tell you what I want to do, but I'm going to give you the legal argument that forces you to reconsider what you failed to consider and that whole second strand of cases you ignored. And we've allowed you to ignore it for too damn long. And nobody could figure out how to get there. And why the idea came to me, only God knows. All I can take comfort in is that he says, I picked the stupid and the weak and the ignorant to confound the wise. So I must be on the bottom of the rung. So yes, I agree with you. Put down your marker. Don't say to them, I'm going to go to you and concede that your law is good and you let me know what I can do and I'll be appreciative of that. No, I believe life begins at conception, and I found a way to do it because we once believed in this nation that there were other rights that did not come from the Constitution. They did not come from a judge. They did not come from a legislative body. They came from God Almighty. And my duty, which you would have heard Adam say, is to secure to people the rights they already had. And we've forgotten that. That's what I'm arguing for. People have rights that don't depend one whit on what you do. You can take them away, and I can go to jail to fight for them. But they don't come from you. I think one of your representatives had a resolution on it that the Senate didn't want to even consider. That was right. The Rule of Law Life bill says, that's right. Those rights don't come from the Supreme Court. And I'm going to declare them. I'm going to do what we've always been charged to do. It's what Blackstone said. It's what the common law said. And here's where life begins. And here's where I draw down my marker. And if you want to strike it down, you can. But I'm not running to you with my hat in my hand and saying, here are 9 or 10 different ways you could let me protect life. How about that? That is, to me, capitulation with all due respect. And I admire your work on this, and I appreciate it. I'm just trying to give you my best advice based on what the court's already said and what I know you and I both believe. Your right to life is not going to come from what the Supreme Court said.
So, wow, that was, I know there's a lot of speeches that have been made in front of legislative bodies all over the country throughout the years, but that was as good of an impassioned plea for the constitutional authority of a legislative body to do its business that I've ever heard. And so just, you were sort of in the moment, just kind of watching that clip again, hearing that back. What are some of your thoughts?
Well, I do think it was a God-provided moment to kind of remind us all that the business of the government is to secure the rights that we already have. And when we fail to do that, we fail to do our job as a legislative body. And actually, that those thoughts are in the Rule of Law Life Act, where we quoted from Blackstone and even from Adam McLeod, who testified to the Senate Judiciary Committee last August, that the first duty of government is to secure the rights people already have. And if they fail to do that, it is an unjust government. And I didn't say it this way because I don't want to say it. I mean, these people are my friends. Some of them I've served with. Their hearts, their intentions, nobody's questioning.
These are good men.
Yeah, they're good people. And their heart's not in the wrong place. And as I told them beforehand, none of y'all are lawyers, and you're being asked in a very short period of time to understand complicated constitutional questions. And that's hard. I mean, you talk to me about technology things, and I'm like, could we just avoid this? Just do it, Gary. I want to show up on the video. I don't care how to do it. Just, do it. So the thing is, you have to appreciate the legal context in which you're fighting. You just can't say, well, I don't care what the Supreme Court says. They have a role. They have a function. They go beyond that function. But the legislature has a function. And to me, the heart of the question that really is there is that, yes, you're right. You should make the policy. But when you go to the court saying, how about at 6 weeks or 10 weeks or 12 weeks or 15 weeks and 18 and 20 and 20, 9 different periods, you're not making the policy. You're asking the court to make the policy. So you want to do your job, then do your job. Pick one.
And what was the case there was a case where the Supreme Court referenced the fact that we don't want to do that job for you. We don't want to. We not.
Oh yeah, that's right. Yeah, that's right. Yeah. I told him that in 2016, in the case of Hellerstedt, I can't remember the first name, but it goes by Hellerstedt. So this is just 4 years old. The same thing happened. A law was passed that had multiple severability provisions. It was not related to the age of the fetus, but it had to do with the regulation of abortion clinics and doctors and so on and so forth. And the Supreme Court specifically said, we're not going to do your job of sorting through which of these policies is preferable. And I quoted it. Here's the quote. A severability clause is not grounds for a court to devise a judicial remedy that essentially entails quintessentially legislative work. We reject Texas's invitation to pave the way for legislatures to immunize their statutes from a facial challenge, saying the law is just wrong. And so what they're saying is, here's what legislators will start doing. They'll say, well, if this law is not right, how about this law and this law and this law and this law? And then we're left up here having to go through each of these laws to figure out which ones would survive. And if you want to put them all together, we're going to treat them as all together. And we're not going to sit here and go through each one. And they said, we're not going to do that. So what I was trying to help the legislature understand, what I want the people who listen to this podcast to understand, the Supreme Court has already said this is how we view these multiple severability clauses. So don't vote for this and go tell people that we're trying to get a heartbeat bill passed. And if we can't do that, then we're going to do this. If we can't do this, we're going to do this. Because the Supreme Court has already said, if you want, I'm not going to do that job for you.
Ain't going to happen. Yeah,
ain't going to happen. You make the policy, and then I'll decide if it's valid or not. Now, another thing came up yesterday that I said, and I want to clarify this. Again, it's not to, demean or punish or call out or anything, but there was, I'd made the statement that no national pro-life organization or national, pro-life legal policy organization or defense firm had come out in support of this bill. And I was corrected to say that, well, actually, there was a letter, and at the top, it's from Americans United for Life, letter in support of Senate Bill 2196, House Bill 2263, from Catherine Glenn Foster, who I know, and familiar with the organization. And he said, so there it is, and it goes on for like 9 pages explaining why, this is a good bill. Well, it caught me off guard. I had not seen that letter, but I got it last night. The representative was kind. He's a friend. He said, sure, I'll send it to you. He doesn't have anything to hide. And I read it. And what she said was, in the text of the bill, I write in support of the bill, specifically in support of the 20-week restriction. Prohibitions against sex, genetic abnormality discrimination, and the ultrasound requirement. So in other words, she was saying, I'm not writing to say this laddered multiple severability approach works. In fact, she doesn't even talk about that. She doesn't address the Hellerstedt case. She never says that I think a court would uphold a heartbeat. So let's just get to the chase. What she's saying is the court might uphold a 20-week ban, but she doesn't address the quote I just gave you that says we're not going to sit here and sort through, 8 different laws until we get to 20 weeks.
And you and I actually have talked about that before. I've done quite a bit of digging too, not more than you have certainly into all these cases, but 20 weeks seems to be sort of the new legally accepted viability standard. And you can look at all of these heartbeat cases and every bill that I've found that has stuck, that where pieces have been enjoined, but some of it, the parts that have not been enjoined, the points that are in effect, the parts that of these laws that are in effect are the ones that only affect abortions after 20 weeks. So the court and everyone is okay with everything over 20 weeks, but that's not the point. That's not what we're arguing for. Forget your 20 weeks. But that's where all this stuff gets lost on these heartbeat bills is that everything's good. And so even in this support letter, we support your bill after 20 weeks, just like everyone else.
Yeah, that's right. So, and one of the things that's interesting, even about that, the justification in Catherine's letter, I appreciate, I get. She says, what we have found is that in terms of the mental and emotional health of the woman, the older the baby is, the more emotional trauma and so on and so forth is. So for the sake, not of the baby's life, but for the sake of the maternal health, the court might uphold it. So see, when you're trying to make a pro-life statement, you're actually making a pro-mother statement, which is a great thing to do. I mean, we care about mothers too, but it wasn't about life is a right from God, a gift from God that we don't just let people arbitrarily dispose of, third parties. Now, I will say this about Catherine's letter. She says, we also know that, or she says, there are some studies that now show that fetal pain begins to kick in around 20 weeks. So the state has an interest in making sure this potential life doesn't go through any pain. Now, actually, she doesn't say that it's definitive, and everybody agrees that you feel fetal pain. There's clearly movement from the child, but is it because of pain, or is it because there's an intrusion into the womb here that's poking around on me and I'm getting away from it? So there are other scientific studies that say, well, we don't know. Now, the legislature ought to be allowed to decide which one it wants to rely on. I would agree with that. But there's another provision from the Supreme Court case in 1979 that was actually cited by the federal district court that enjoined the Missouri law. Okay, let's not forget, the federal district court enjoined it, which, you'd expect them to. But here's one of the things that he said about this laddered approach. The Supreme Court said, and I'm going to quote again, it's Culotti versus Franklin, "Neither the legislature nor the courts may proclaim one of the elements entering into the assessment of viability." So in other words, there are a lot of elements that go into this question of whether the fetus or the unborn child is enough of a person to be constitutionally protected. So if you don't have enough of those characteristics, you're not a constitutional person, and it doesn't matter what we do to you. Okay? It says, "Neither the legislature nor the courts will proclaim one of the elements entering into that assessment, be it weeks of gestation or any other single factor, as the determinative of when the state has a compelling interest in the life or health of the fetus. Viability is the crucial point, because it's a legal point, not a medical point. Has nothing to do with whether the fetus has a strong heartbeat or weak heartbeat or brain waves or, all those things go into it. But don't just come in here and say, well, we ought to do it at 20 weeks because they feel pain. Now, maybe the court would say pain is enough to stop it after 20 weeks. But we don't know that. We have to address the reality that those decisions are out there.
Well, and that point continues to support what you've been saying very, very often, that all of these arguments being made still accept Roe and Casey as precedent. That's right. You're still all of those things, and like everything you just meant, you're still arguing within the framework of Roe and Casey. So no matter what the court decides on those issues, you're not giving the court anything by which to do away with Roe and Casey. We're not doing the job of getting rid of that bad law.
Yeah, what we may be doing is modifying it somewhat.
Sure, we're moving the goalposts a little bit.
Yeah, we're moving the goalposts, potentially there. But when you put in the bill, which the governor's bill does say, that every human being, including the unborn, has a fundamental, absolute right to life, why would you then say, but not at the point of conception, not at the point we know there's a life? It's not that fundamental. It's not that absolute. It could be any of these other places.
If that's your conviction, why fall short of anything less than protecting that life?
That's right. That's right. I want to win the game, but a tie will be fine. Now, one of the things that I would say about this, because I hear this all the time, well, we've nibbled around the edges for years, and we've been doing that, and that strategy's been good, and that's all we've ever had. And I've said, that's right. But when you're talking about how should we regulate the doctor's licenses and admitting privileges, when you're talking about how clean should facilities be and how close should they be to hospitals or all those kinds of things, you're not talking about the question of life itself and what constitutes a person. You're talking about what constitutes a qualified doctor, what constitutes a qualified facility. And I don't mind nibbling around the edges to do that. But when you put to me the question, can we nibble around whether you're a human being or not? Well, I have to draw a line there and say, well, no, you're a human being from the point of conception or at the point you get out of the birth canal. Those are the only two objective places. That's it. And so you're right. If you want to keep arguing within Roe and Casey, and the governor's bill accepts that is the constitutional, those are the constitutional precedents that apply, you're not going to get rid of it. You might modify it, but then you have to address all these other cases, like Hellerstedt, like the Culotti case, because you've said, I'm willing to be dumped into that pot. So now I have to play within that little pot. And what the Rule of Law Life Act is saying, well, I know you have this little pot over here of 14th Amendment stuff, and you got Colati and you got Hellerstedt and all that sort of stuff. But we're going to go over here and refer to a provision in the Constitution. The Supreme Court has already said in 1802, every provision of the Constitution means something and has to have some meaning. Well, it's never been asked to address what is its meaning when it comes to abortion. What does the Ninth Amendment mean when it says there are other rights than those we've enumerated?
Yeah, when it comes to the word life.
When it comes to the word person,
what does the Ninth
how do we
Amendment
understand
mean?
those?
Yeah.
That's right. So we're taking ourselves out of that pot. And I played for him yesterday, Adam McLeod's testimony. He was specifically asked by Senator Kerry Roberts, who then turned around and voted for the governor's bill instead of the Rule of Law Life Act. But he said in August last year, Mr. McLeod, we've only heard about 14th Amendment cases. You're now making a Ninth Amendment framing the argument in the terms of the Ninth Amendment. Are Roe and Casey precedent? Would they be things we'd have to run into and justify and try to worm our way around and say, yeah, I know you said viability, but there's some fetal pain here, and now there's more emotional harm to the mother? He said, no, they are not precedent.
Yeah, that was last year in the summer study before the Senate. Our friend Professor Adam McLeod. I actually have this clip. Here, let's go ahead and take a listen to that real quick.
Yeah.
Senator Roberts, you're recognized.
Yeah, just very, very quick question. When we think of Roe or Casey, we think of it in the context of a 14th Amendment argument. But you're presenting a Ninth Amendment argument, common law. So my question is, are Roe and Casey, are they precedent with respect to this Ninth Amendment argument?
Senator Roberts, no, they're not. In fact, the court in Roe expressly bracketed and set aside the Ninth Amendment question. As I'm sure you remember, the district court in Roe had ruled on Ninth Amendment grounds. And Justice Blackmun, writing for the court in Roe, said, we're not going to touch the Ninth Amendment. We find the privacy interests at stake here in the liberty interests secured by the 14th Amendment. So the court in Roe actually didn't touch the Ninth Amendment, and the court in the abortion context hasn't done so since. The more apposite precedent, I would argue, is Gonzales versus Carhart. And the reason is that the reason which prevailed in the court's opinion and explanation, Justice Kennedy's opinion in that case, was the state's substantial interest in protecting the life of the unborn. Now, a jurist who knows the common law tradition of the Ninth Amendment, security for Ninth Amendment rights would say that interest is grounded in a common law right, a natural right, the absolute right to life.
Okay, thank you.
So can you kind of elaborate on Adam's answer regarding precedent?
What he's saying is that we would have to acknowledge that Roe and Casey are there, but we're not trying to get them to modify it. We're explaining why it was wrong. Because the Supreme Court, here's the fascinating thing. We talked about this case a few weeks ago, Ramos versus Louisiana. I don't know, episode 26, 25, 26. The Supreme Court, even today, goes to the common law to find out what words in the Constitution mean. In that case, it was a right to a jury trial. They do it all the time. They did it twice last year, at least twice. And so the point that Adam is making is that when Roe was decided, the court did not look at how the common law understood the word person. They only looked within the text of the Constitution to say, well, every time the word person is used, it's about not having to testify against yourself or not having your home invaded by the militia or whatever else. And so it appears that the word person in the document only means to somebody who's been born and is alive. Well, see what he did? He ignored that whole strand of cases where the Supreme Court says we actually look at the common law to define the words in the Constitution. And what we've struggled with is how do we get out of that vicious circle of only looking inside the Constitution? Well, the Ninth Amendment says look outside the Constitution. That's what it says. Yeah. We have other rights not in the Constitution.
Yeah, there are other rights, right?
That's right.
That's what it means.
Right. That's right. Now let me tell you why this is so important to me, to Christians, beyond the issue of abortion. The fact is, what's happened in the legal culture, I mean, this is what I was taught. I didn't have a professor like Adam McLeod, but they believe that law is whatever man says it is, as long as it follows the agreed upon procedures by which it's enacted. So you really can't say a law is good or bad as an inherent matter. You can only say it was properly adopted or it was improperly adopted. You know, they didn't actually get a majority vote for the bill because there's no reference point outside what man says. The Ninth Amendment is asserting a conception of law as existing before man ever existed. And man's going to spell some things out in the Constitution, but those things are not declarative of all there is. There is a God who has established a law. And our culture and the church have ignored that and allowed the judicial system and lawyers and Christian lawyers to argue as if there is no other law, as if it is irrelevant. And in doing that, let's just put it on the table. They have denied God in that instance. Mm-hmm. And that is sin. You have denied God the glory that is due God for having created a universe that in every sphere, universally, in all aspects, is governed by his law. God didn't say, I'm going to make a law to govern just, natural things like gravity. He made a universal law. So when you start saying, no, God only made laws for the natural world, you have denied the universality of God. You've denied the omnipresence of God. You see how sinful we are? Mm. And we just blithely go along. No, God's law doesn't have any bearing to do with this. Well, then you have denied that God has any bearing to a part of his created order and has any concern or interest in it, and that is blasphemy. Let's just put it out there. You've denied who God is. You've denied him his glory. And what does Paul say? To fall short of the glory of God is sin. Mm. So we got a bunch of Christian lawyers and Christian judges and Christian legislators who are operating in the kingdom of darkness that you talked about at the top of the show, and they don't even realize it.
Don't even realize it. Yeah. And
that's what we're fighting for, more than an abortion.
And what's clear about the Ninth Amendment, like you say, it's not only that the Ninth Amendment acknowledges that law is there. That's the one thing it does. It acknowledges that there is a separate law, a God-given law, a natural law, but by also asserting that the Constitution shall not infringe on those laws, it's acknowledging that it is a higher law. So that's
a great point. That's right.
The Ninth Amendment is saying we're not only saying that these sets of rights exist outside of the Constitution, we're also saying that this set of laws is a higher authority. There is nothing we can put in this Constitution that shall deny the authority of this set. This set is higher. Yes. It is set above. That's an excellent point.
It's the Declaration of Independence. We have certain rights that are endowed by our Creator, and they're not
alienable in any situation.
That's right. And see, that's why in the quote, the little clip you played earlier, I said that the founders understood the purpose of government was to secure the rights we already had. Mm-hmm. And that's what the legislature needs to assert, and that's never been asserted to the United States Supreme Court. We've never made the argument. And that's why Professor McLeod said those cases are not precedent. There are other cases. There are other precedents where the court has acknowledged that there are natural rights, like between parents and children, natural rights related to marriage. I mean, the Supreme Court has a whole strand of cases that acknowledge this pre-existing kind of law that the Constitution can't, by man positive law, interfere with. It's there. Those cases are there. What we've not done is we've not asserted them. We've not accessed them. We've not known how to access them. Why do we not know how to not assess them? It's because we think so much in terms of positive law, we don't even realize there's this pre-existing law.
Well, God used a lowly man such as yourself to show us the way, like you so eloquently said.
And let me just say this. I think I did say it, and it's not a clip you've got today. I would have supported a bill like this 3, 4, 5 years ago because I was so enslaved to that way of looking at the law. I couldn't think any differently. It's only because God providentially brought Adam McLeod and Rob McFarland into my life that I was introduced to things that I did not study in law school. And why have I put these 2 and 2 together to come up with this Rule of Law Life Act? Because I'm some genius? Because I'm some, gift to the world? No. As I said yesterday, in 1 Corinthians, we learn that God chooses the weak and the foolish in the eyes of the world to confound who the world calls wise and strong. And so I can only give all the glory to God and can only say he chose me, I believe, to put these 2 things together because no one would believe that I could do it, and they'd have to give the glory to God. That must have been a God thing. David's just not that smart. And I'd say, you're right. It's a God thing. And maybe that's a good way to close with, we fight against principalities and powers.
Well, and as we close too, I want to sort of set, to everyone that's following, that's following this issue, I want to make sure they understand where we sit. And you can, I'm sure there's things we can and can't say. You can embellish anything you want to. I'll just say the what I know we can say. So as it stands right now, after your testimony to the House Subcommittee, we still have the 2 bills passed through Subcommittee. Now they're being sent to the full Health Committee of the House, which I believe is scheduled for next week.
Yes, next Tuesday.
So we still have 2 bills.
Right.
We don't know what will happen, whether or not one or both of those bills will then go to the House floor for a vote.
That's right.
Most likely, something like that will happen. I guess at this point, we probably feel like something will come out of the House. Something will go to the floor for a vote, whether it's one of the bills, both of the bills, or an amended version of the bill. One of those things.
Right.
And then we've got the Senate. My understanding is we have no clue right now what's going to happen in the Senate. I think things change on a daily basis, but that's where we are today. If you want to, there's anything further you want to add to that?
I'll just elaborate a little bit. I did learn on Wednesday that the Senate, that the governor asked the Senate not to take up any of his legislation except for, I think it's a early childhood or literacy kind of bill. He said, I am so swamped with figuring out how to fix a $600 million budget hole between now and June 30th. And a budget for next year. See, they have to finish this year in the black by June 30th. And
come
by
up
June
with
30th,
next year's budget.
yeah, which may be $1 billion off. And he said, I don't have time to go over here and be calling legislators or lobbying legislators and working on these other bills.
Which is reasonable. That makes a lot of sense.
Which is reasonable. Yeah. That's right. And in fact, I would notice that yesterday, unlike what happened when the bill was heard in the Senate Judiciary Committee, the governor's attorney, Lang Wiseman, went to the Senate Judiciary Committee and explained the bill and answered questions. Yesterday, he did not show up. It was left to legislators to go over the bill. And I thought it was surprising he wasn't there. And it may have been simply because I don't have time to be sending my chief legal counsel and chief deputy over to the Senate to be working on this bill. I need him to get our budget straight. And I don't know, the word may come down from the governor. I love you guys and I appreciate you guys, but I know there are things that need to be fixed in this bill. In fact, Committee Chairman Brian Terry said at the end of the hearing, there are things in this bill that are medically inaccurate and I can't vote for it. And do you promise me between now and next week, you'll work with me to get the bill at least medically accurate?
I heard that.
And maybe they'll do that. But it may be the administration says, I hear what you're saying, and I have no problem with what you're saying. I just don't have time to be sitting over here spending 2 or 3 hours trying to get this other bill right. Just please focus on COVID for now. And to be honest, I hope that's what happens so that we have more time for everybody to think through what is a complicated legal issue and what principles are really at stake. because it is about more than abortion.
Well, it was providential to even get the opportunity yesterday to be heard in the
Yeah,
House.
that's right.
We weren't sure that any of that was going to happen at all.
That's
So
right.
it was-
Yeah. So that was good. Yeah. It was good.
Well, thanks again, David, for your work. I thought, and we'll post too. We have this clip, but also we're gonna. Well, actually, I'll post clips. But if you go to our Facebook page right now, if you go to, you can go to facebook.com/GodLawLiberty, or you can go to /Fact Tennessee. And we live streamed. It was like an hour and 45 minutes. We live streamed the entire testimony on these abortion bills, and they're on the page now. So I would encourage anyone who's interested, you can go and watch that entire House hearing there on our Facebook page, and there was some really great stuff said. Well, David, thanks again for your work, for your testimony, and as always, we're glad you're with us here on God, Law, and Liberty. You can email us at info@factn.org. That's info@factn.org. We welcome your questions and your comments, and we'll see you next time. God bless.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's FACTennessee.org. And please follow us on Facebook, Twitter, and Instagram @FactTennessee.